Welcome you all to our highly anticipated webinar on top 3 Supreme Court judgments of 2023 and how to crack CLAT PG 2024. In the ever-evolving landscape of the legal domain, staying updated on the latest judicial decisions and preparing effectively for the competitive CLAT PG entrance exam are of paramount importance. Our expert panel of speakers will guide you through the help you excel in the upcoming CLAT PG 2024, ensuring you are well prepared for the challenges and opportunities that lie ahead. Before we begin the webinar, sorry, I would like to introduce Legal Vidya to you all. Legal Vidya is a platform that was founded in the year 2021 with the vision of empowering young lawyers. The organization provides a comprehensive portal where people can enhance their knowledge and grow their expertise in the field of law. Legal Vidya offers various opportunities such as internship programs, a platform to publish articles, and host interactive webinars and sessions for our members. Now, I would like to introduce SR CLATs. This project is the brainchild of two NLU graduates. After attempting and cracking CLAT PG exam, we took up upon ourselves to understand the exam syllabus and provide well-curated notes for our students who wish to appear for the CLAT PG exams. Now, it is with great pleasure and honor that I introduce the distinguished speaker for today's webinar is Ms. Sukanya Subramaniam ma'am. With her BA LLB honors degree, is a shining example of excellence in the legal profession. Her remarkable accomplishments in the CLAT PG examination, securing AIR 347 in 2019 and AIR 246 in 2022, underscore her academic powers. With over 3 years of experience as a corporate lawyer, she brings a wealth of knowledge and expertise to the table, making her a valuable asset in the legal field. Her commitment to the pursuit of justice and her legal acumen are truly commendable. Now, I would like to introduce our second speaker, Ms. Rintu Mariam Biju, ma'am. She is also a graduate from the National University of Advanced Legal Studies, has carved her own niche in the legal world. Her recent achievement of securing AIR 1035 in the CLAT PG examination 2023 showcases her ongoing dedication to her field of work. With over 4 years of experience as a senior legal journalist covering the Supreme Court and other high courts as well, Ms. Biju has proven herself to be a trusted source of legal information and insights. Her in-depth understanding of legal proceedings and her ability to, to communicate complex legal matters to the public make her a vital contributor to the world of legal journalism. So without further ado, let us warmly welcome Ms. Rantu Mariam Biju ma'am to the virtual stage. We eagerly await the invaluable wisdom and perspectives they are about to share with us. Over to you, ma'am.
Hello, everybody. Am I audible?
Yes, ma'am.
Ma'am.
Thank you. Thanks. Thank you so much for the lovely welcome. Thank you so much for talking about SR CLAT notes. And without any further delay, I think there's already been, 10 minutes of delay. So let's quickly dive into it. So for better understanding and comprehension, we have prepared a PPT, which will be helpful for all of you as well. So if you want to take down notes, you're free to do that. So before we start, I just wanted to say something about our organization. We started this year, and however, we have been in terms of collating data and in terms of understanding Supreme Court judgments for a really long time. Both of us have cracked CLAT PG thrice, actually, and we would love to take this opportunity to tell all of you a very good luck for your examination, first of all, the upcoming one, and well, if you need any kind of guidance from us, we have exclusive courses for all of you, which we'll be talking about in detail at the end of the session. So do wait, and you will get to know a lot of things. So I'll start presenting, and please do confirm if you are able to see it. Can you please confirm if you're able to? Is it visible?
Yeah, it is visible, Rintu.
Okay, thank you. So, like I said, we are a CLAT PG course developer, and we have experience in corporate law practice and legal journalism, and we have cracked CLAT PG thrice. And here we're sort of focusing on Supreme Court judgments, and we simplify it for you so that you're able to understand and perform better for your exams. And we simplify it in such a way that anybody with absolutely no, what you say, understanding of the judgment can understand. We use diagrams, tables, and all such tools for your better understanding. So let's dive in quickly. So today you were promised three important Supreme Court judgments. However, we are bringing to you more than three important judgments, and we're going to be telling you tips and tricks on how to crack your CLAT PG examination. So the first case for today is Supriyo Chakraborty versus Union of India. There was a lot of talk about this very recently because a judgment was pronounced on October 17th. This was by a 5-judge bench, a constitution bench. So before we dive into it, it's very quick or very important to understand what the case was about, right? So this was about legalizing same-sex marriage. So in November, a queer couple, they went to the Supreme Court seeking legal recognition of their marriage. At that point, 20 odd number of petitions were clubbed with it, and the Supreme Court heard the matter for 10 plus days. So next, we'll try to understand the issues, right? The first issue obviously was the right to legalize a queer person's right to marry. Is the Supreme Court the right forum, or is the parliament? That was the number one question. Then the second question is there a fundamental right to marry? Then the third aspect is on a civil union. And the fourth is about the SMA, or the Special Marriages Act. Is it unconstitutional for excluding non-heterosexual couples? Can the right to marry be read into provisions of the SMA? Can unmarried non-heterosexual couples adopt? This question is about adoption. And lastly, can transgender persons in heterosexual relationships marry under the existing laws? So these were the issues that were framed by the Supreme Court, to which there were dissenting opinions as well. On the first issue, the current Chief Justice of India, Justice Chandrachud, indicated that the Supreme Court was the appropriate forum, as the Supreme Court has the powers, and the powers of judicial review was talked about. Even the doctrine of separation of powers was talked about in that particular judgment. However, Justice Ravindra Bhatt disagreed with this view. On the second issue, the bench unanimously agreed that the Constitution does not confer a fundamental right to marry. Justice Chandrachud even pointed out that even states are free to make their own amendment to laws with regard to the institution of marriage. And this right to marry is according to your preference, your social status, and therefore is not an enforceable right. On the third issue, there was a split, again, a 3:2 ratio. Justice Chandrachud and Justice Kaul, who gave the dissenting opinions or the minority opinions, recognized queer couples' right to enter into a civil union. And for this purpose, they took the help of Articles 19 and 21. When you talk about the majority opinion with regard to the same issue, it was led by Justice Bhatt, but it was of the, a very important aspect with regard to civil union was talked about, and the judges stated that the state or the government or the parliament is not obliged to recognize civil unions, neither can the court direct the parliament to do so. And we have judgments for that. The court cannot issue a mandamus to the parliament to make a law. On the fourth issue, the bench gave a unanimous decision with regard to the provisions of the SMA, stating that the act is not unconstitutional. In fact, the judgment ardently stated that it is a progressive legislation, and the intention of this act is very important, right? It is to understand and facilitate marriage between persons professing different faiths or religion. Therefore, SMA has no nexus with the exclusion of non-heterosexual couples, is what the judgment said. On the fifth issue, the bench gave a collective decision that the right to marry cannot be read into the provisions of SMA. This is connected to the fourth point, because doing so would require amendments to the legislations like the Hindu Succession Act, the Indian Succession Act, which is beyond the power of the particular court. So again, that was what the court said about that particular issue. When you come to the sixth issue, there was a split verdict, again, a 3:2 ratio. This is with regard to adoption. Justice Butt said that adoption cannot be granted, or the right to adoption cannot be granted, especially because Section 57 of the Juvenile Justice Act talks about joint adoption. That's only by married couples. Unmarried couples cannot do so. However, the minority judgment stated that unmarried heterosexual couples can adopt, thereby giving them a right to adopt. Just, this is the dissent. Please keep that in mind. Because the reasoning was that statistically, there was no data or no proof to state that only married couple can be a stable couple. On the seventh issue, the bench gave a unanimous decision stating that transgender persons in heterosexual relationships can marry under the existing marriage laws. Justice Chandrachud stated that a person is a transgender by virtue of their gender identity and not sexual orientation. This was also a very important aspect with regard to his judgment, which was the dissenting judgment. And the court also gave several directions to the union, to the state, and to the union territories to ensure that queer couples are not discriminated with regard to any aspect. And the court also issued directions to the police for the fair treatment of queer individuals. So these are the different issues, and this was the judgment with regard to the different issues as well, which include the dissenting judgment as well. Without any further delay, let's go on to the second important judgment. That is the Animal Welfare Board of India versus Union of India. This mainly talks about the Jallikattu decision. This was also a constitution bench decision. So again, to understand, this was basically about two bovine sports, that is Jallikattu and Bullock race in Tamil Nadu and Maharashtra basically. In 2014, a judgment was passed by the court, and that sort of stopped the court from entering or continuing the act of Jallikattu and other bovine sports. Later on, an amendment was passed on by the state government, and that is what is being challenged in this case. The state sought to legitimize Jallikattu in Tamil Nadu, Bullock race in Maharashtra, and Kambala in Karnataka. These amendments by the state governments were challenged on the ground that it overrides the 2014 judgment. That is Animal Welfare Board of India versus A. Nagaraja, the 2014 judgment. So here also we have a couple of issues. The first thing is whether the Amendment Act in Pith and Substance to Entry 17, List 3 of the 7th schedule to the Constitution of India, does it perpetuate, is it valid, or does it perpetuate cruelty to animals? Second is whether the Amendment Act would receive protection under Article 29 of the Constitution, that is with regard to cultural heritage. The next would be whether the Amendment Act is contrary to Articles 51AG, 51AH, and violative of Articles 14 and 21. Let's see what the court said. So firstly, with regard to I.N. Saxena versus State of Madhya Pradesh, the court laid down that legislative lists in the Constitution ought to be interpreted not in a narrow but a wide amplitude. So the court basically found no flaw with regard to the amendment because the court was of the view that the amendment received the presidential assent under Article 254, Clause 2. The court said that the 1960 Act in whole and subjects of the three amendments directly deal with the question of prevention of cruelty to animals. So there is no other entry in any other list, and in such circumstances, the court was forced to reject the contention that the petitioner stated, which was that the state legislature inherently lacked the jurisdiction to bring this amendment when the 2014 judgment was already in place. The court also said that expressions like Jallikattu, Kambala, or Bullock race, as introduced by the Amendment Act into these three states, were quite different from the 2014 after the 2014 judgment came out. There was a lot of differences. That is with regard to the practice or the performances or even the factual conditions that prevailed at the time of 2014. It cannot be equated to the present situation because situation has changed. The court was of that opinion. And the court was satisfied that a large part of the pain-inflicting practices such as hitting the animals or provoking them, whatever prevailed in that point, as in when the 2014 judgment came out, that is before the pre-amendment period, that is between 2014 and 2017, that was substantially diluted by the introduction of these three statutory elements. Another argument that was placed by the petitioner was that in reality, the welfare measures that the amendment sort of states to bring in may not be practiced, and whatever was existing earlier would continue. But the court said that that is not a good practice in law, because they cannot exercise their judicial power on the assumption that the law has to be struck down because there is an apprehension of abuse or disobedience, and that is not a good practice in law. And the court further said that because the Amendment Act has already received a presidential assent, the court did not find any flaw in the state action. This is a very important paragraph that we have sort of put in. This is directly culled out from the judgment for your better understanding. And I would like to go on to the next slide. With regard to the second issue, the court said that whether a particular practice or an event or something, whether it is part of culture or not, it is not the court's duty to decide or to look into that particular aspect. In the 2014 judgment, the Supreme Court had categorically stated that there was a judicial determination about the practice being offensive to the central statute, that is the 1960 statute. But in this judgment, what the court said, that to understand whether Jallikattu has become an integral part of Tamil culture or not wasn't an exercise for the judiciary to undertake. And because the amendment had already come in the 2017, after this exercise was done in 2017, an amendment had come, the court said that there was no reason to sort of disrupt that view of the state legislature. With regard to the third issue, it was basically on the fundamental rights, whether fundamental rights can be extended to animals, or do they only have legal rights, or do they even have legal rights? Firstly, the court said that there is no precedent for the fact that animals have fundamental rights. In 2014, also, the court had not laid down that animals have fundamental rights. The only tool available for testing this proposition is interpreting the 3 amendment acts on the anvil of reasonableness in Article 14. The court said that it was not wise to go into judicial adventurism to bring bulls within the standard mechanism. And here the court really talks about habeas corpus petitions as well. For example, if a bull is missing, would there be a habeas corpus petition, or can that even be possible? These aspects were gone into. Again, we have culled out an important paragraph from the judgment so that it can be better understood by all of you. So for all these reasons, the court said that the Amendment Act is not contrary to the articles in the Constitution and does not violate the provisions of Article 14 and 21. So that's about the second judgment. We're directly going to the third one. This is State of Andhra Pradesh versus Varla Ramaya. This is a 2-judge bench case. Again, so here also the facts are not very complex. It's quite easy to understand. This is basically a case against an Andhra Pradesh High Court order which stayed an investigation by the SIT, and the case was into the alleged financial irregularities of the earlier chief minister from the TDP party. And the allegation was that there were a lot of scams that were happening because of large-scale projects and schemes, including the Amravati land scam case. So the government ordered a detailed investigation, but the Andhra Pradesh High Court subsequently granted a stay on the SIT probe because a petition was filed by the TDP party. So naturally, this was challenged by the current party, and the matter reached the court. So here the main issue is, can the state form a fact-finding probe into the allegations of corruption of a previous government? Does that mean you're going against a decision of the previous government? Is that possible? Can the new government or the ruling government do that? These were the aspects that the court went through. Here the court ruled that the state can form a fact-finding committee to probe into allegations of corruption of the previous government. So what the High Court said is that the new government cannot be permitted to overturn the decisions of the previous government. The Supreme Court did not agree with this view, and this is what they said. The court further said that the High Court had misinterpreted the 2 government orders, as in the government orders for ordering investigation, and that does not mean overturning the decisions of the previous government. It cannot be equated to the same. The court said that the government orders are not overturning the earlier decisions, and the court highlighted that aspect. And again, there's a paragraph from the judgment directly. So based on these observations, the court set aside the Andhra Pradesh High Court order staying the SIT probe. So apart from this, we also have a couple of other important cases. We won't be going into the factual aspects because we do not have that much time, but we'll quickly run into what are the cases. So this is Coal India Limited versus Competition Commission of India. This judgment is very important because in this judgment, the court said that Coal India, even though it is a PSU, would come under the purview of the Competition Act 2002. So this PSU, Coal India, had filed petitions before the Supreme Court, arguing that it operates coal mines covered under the Coal Mines Nationalization Act. So because of this, it would not come under the Competition Act and it would come under the Nationalization Act. Naturally, CCI opposes. Now, the whole thing happened because there was a penalty of 1,773 crore rupees that was imposed on Coal India for unfair and discriminatory practices like fuel supply agreements with the power of producers for the supply of non-coking coal. So there were multiple aspects, or there were multiple important, aspects in this judgment. But one of the key aspects of this judgment is stating that, even if you are a PSU, you would come under the Competition Act. Here, the court is also dealing with the scope of the Competition Act as well as the Coal Mines Nationalization Act. And there is a comparison, and the court really goes into the intent of the Competition Act as well. So that could be a very important case as far as CLAT students are concerned. The next one would be Dr. Balram Singh versus Union of India. Again, a very important judgment because this deals with manual scavenging. So this was a PIL which sought to implement Employment of Manual Scavengers and Construction of Die Latrines Prohibition Act 1993 and the Prohibition of Employment as Manual Scavengers and their Rehabilitation 2013. So here what the court did is they have issued a plethora of directions to the union as well as the state government to ensure the complete eradication of manual scavenging. Second, the rehabilitation of those in practice, which includes employment of their kin, education to their wards, and also some kind of skill training so that they can do something else in the future, and also awarding a compensation of 30 lakhs. So there was another judgment which stated that 10 lakhs should be given. However, there was a calculation done by the court, and the court said that currently that value of 10 lakhs would be 30 lakhs right now, and that should be given to the families of those manual scavengers who succumbed to death while they were in the process or in the act of manual scavenging. The next important case would be Indra Kunwar versus State of Chhattisgarh. So here the court really delves into what is the aspect of Section 313 of the CRPC. So while acquitting a woman who was accused of killing her own child, the court sort of laid down 12 important principles with regard to Section 313 of CRPC. We have enumerated a few of the principles. So the court looks into what is the object of the section. The object is to enable the accused themselves can explain any circumstances appearing in the evidence which is against them. So what is the intent here? The intent is to establish some kind of dialogue and discussion between the court and the accused. This actually helps both the parties, right? One is it benefits the accused so that they can tell their version. Two, it helps the court in coming to a better or a final verdict by understanding the entire, facts. Now, this is not just a procedural formality because it is based on the cardinal principle of natural justice, that is audi alterum partem. You have to hear the other side. The ultimate test when concerned with the compliance of the section is to inquire and ensure whether the accused got the opportunity to say his piece. And also, while you're making such a statement, the accused may or may not admit to the involvement or incriminating circumstance, or even after an alternative version of events and interpretation. That is, they may say their own version, what they think happened or what according to them happened. But the court says the accused should not be put into any kind of prejudice by any omission or inadequate questioning. The accused cannot bear the brunt if there is any kind of inadequate questioning. And there are other principles as well. We have just jotted down the most. There are 12 of them. The next one would be Vivek Narayan Sharma versus Union of India. This was with regard to demonetization, whether the act of demonetization that happened years ago, whether it is lawful or not, that was the question here. Here also, there was a 4:1 majority. Justice B.V. Nagaratna gave her dissenting opinion. So the court, the majority, was of the view that the central government has the power to demonetize all series of banknotes of a particular denomination under Section 26(2) of the RBI Act. Now, provided there is, this is very important, provided that there is a recommendation made to the central board and the process has to be initiated by the central board itself. The court also said that the RBI notification, which gave out the aspect of demonetization, satisfies the test of proportionality and therefore cannot be struck down on that ground. And there is no excessive delegation of power. That too was added by the court in this judgment. The next is KC Cinema versus State of Jammu and Kashmir and others. The High Court said that there was some kind of mistake in law with regard to the High Court's view. The Supreme Court said that the High Court was wrong. Now, here what really happened was the High Court said that moviegoers cannot restrict, or basically the High Court sort of ordered cinema hall owners to not prohibit moviegoers or people who go to theaters to bring their own food and drinks from outside into the movie premises. So the court said that the High Court was wrong in saying that. Now, why? So there is this another case, Kaushal Kishore. The court relied on this case, and the court said that directions cannot be issued to private cinemas, but directions that are contrary to the legislative mandate, that can be issued, and those are not justified. It's not that you cannot give out directions to private cinemas, but if you're giving out any direction that is contrary to the existing law, that is a bad practice in law. And here, basically, the court is trying to balance out two things. One is the fundamental right of the cinema hall owner to sell food of their choice, that is under Article 19(1)(g), and the right of the movie goer to bring their own food or snacks, that is to food. So here, the court obviously favored the first aspect and not the latter. Now, this part will be handled by my partner and co-founder, Sukanya Subramaniam. I'm handing over the mic to her, the virtual stage to her. Thank you so much, everybody, for for paying attention, and I hope this was very helpful for all of you. And all the best for your exam. Sukanya, please.
Yeah. Hi, Rintu. Thank you so much for the presentation. Can you please put it on full screen?
Just a moment.
Yeah. Yeah. Hi, everyone. My name is Sukanya Subramanian. So I'll be taking over the second part of the session. So second part will be dealing with, how to crack CLAT PG exam 2024. So most of the tricks and tips that's provided under in this PPT, it's based on personal experience and as well as the trend that is seen in the current scenario. So firstly, what we have done is we have collected data over the years 2021, 2022, and 2023 regarding the questions that are coming in CLAT exam. So if you see if you see the chart here, the trend shows that the law of constitution remains the most important topic for CLAT exams. Second place will be taken by criminal law. Thirdly, now we are seeing a trend of increasing questions from the corporate law. Like last time, the last CLAT exam, we saw 20 questions from corporate law, which was not seen before. Then we are also seeing questions from family law and contract law, and jurisprudence. The importance of jurisprudence has fallen down, and they are also introducing new elements like new laws like Income Tax Act and even intellectual property rights as for comprehensions. So this is the latest trend that's happening with respect to CLAT exam. Now, if we move forward to the next slide, we'll be seeing what's the expected weightage under all these subjects. Pinto, please move to the next slide. So this is the data compiled for the years 2021, 2022, 2023, and we expect that in the year 2024, law of constitution, the importance of law of constitution will remain the same, that we will have at least 30 questions, but the importance of corporate law will also increase. So we are calculating at least 12 to 18 questions to come from corporate laws. In the year 2023 CLAT exam, we saw 20 questions coming from corporate law, that too from SEBI insider trading and CSR under Companies Act. It was never seen in prior examinations in CLAT exams. Then also the importance of jurisprudence is falling down. Then last year, we did not find any questions from family law. So we are expecting that this year, there will be questions from family law and also from criminal law. Then environment law, jurisprudence, property law, all these topics, they are always remains, static, always like, and you can find miscellaneous passages also, where you don't have to rely on any passages, but then still you will find questions coming from these topics. So for that purpose, you need to also brush your memory in these subjects. Can we move to the next slide? Okay. So we have formulated a method of attempting this exam. So what I would do personally is that I would divide my time into two phases. So in first phase, that's, let's take 60 to 80 minutes. We will read through all the reading comprehensions, and we will answer the questions that we know the answer, that we know it's the correct answer. And we will mark or park the questions for which we are not sure of. Like, let's say we are not 50%, we are not sure what's the correct answer. So then we won't go and mark the answer then and there, but we'll park it for later evaluation. So after a first round, where we will answer majority of the questions, you will come back after this 80 minutes, you will come back and reevaluate the questions that you were not sure what the answer was. Then you can do it two phase, you can complete the entire paper. Second important thing is that when the second round for questions that you don't know the answer properly, you should apply that elimination method. So elimination method is when you see four options and you don't know what's the correct answer. So what we can do is, you can, first thing is to eliminate the answer which you think is definitely not the answer, that this is not the correct answer. So you can eliminate options like that and reach the most probable answer which you think this might be, or most probably this will be correct. So you will be picking such an answer. So you should apply elimination methods if you are not sure what's the correct answer. Third important fact that you do look is, so if you are aiming for at least all India rank 200 or below 1 to 200, let's say, you need to at least attempt 110 to 115 questions. We have a total of 120 questions, and there's also negative marking. So you need to at least attempt 110 to 115 if you want your name in top 200 ranks. But if you want to come within, you're okay to come within 1000 ranks, 200 to 1000, then you can attempt at least 90 questions, 19 to 100 questions. Also, but you should ensure that your accuracy level is at high point. So another important thing is, accuracy is the key to crack all these exams, because we have negative marking of minus 0.25. So because of this, you cannot go and click all the answers or mark all the questions, because there is negative marking. And so what happened, a lot of candidates, what they do is, they want to attempt maximum number of questions, so they'll go attempt 120 of them, but 60 might be wrong. Then what's the point of attempting all these 120 questions, right? So you should always make sure that you have accuracy, and you don't go around answering all the questions just to finish the number of questions. It's not necessary you should finish 120 questions. You can also attempt 110 and still crack CLAT or in the top rank. So you don't have to answer all 120 questions. So that's why accuracy, you should make sure 85, 70 to 85% accuracy must be there while you answer the questions. Rintu, can we go to next slide? Okay. Then another important thing is, the CLAT exam from after 2019, they have completely changed the pattern. So they are giving reading comprehensions. You know, every passages will require at least 2 to 3 minutes to read, and there will be 6 questions at least coming from that passages. So the key here is, rather than a static normal exams where you are just expected to give a one-word answer, this question. Example, they ask right to life, which article is right to life under. We all know it is article 21. It's easy to answer, but that's not going to be the pattern for CLAT exam. So you need to read the comprehension properly and understand what's given in the comprehension properly, and then give your answers, because all the questions, they are based on these comprehensions itself. And lastly, you need to have patience, because you need to read all these passages, so you need to have the patience to complete the paper. And also avoid anxiety, because people usually get scared of seeing no time limit and everything. So you need to have presence of mind while attempting this paper. So now we'll be looking at model questions. So this is a question taken from CLAT PG 2023 paper. This is so basically this question says that, what is the spending obligation on corporate social responsibility, CSR activities under Companies Act? It's given under section 135 of the Companies Act. Now, it's a static question because you cannot apply elimination method or any other method to come to this answer, because the answer is 2% of average net profit. It's a static answer. So this will be the type, some questions will be like this way, direct questions, you can have direct static answers where you cannot apply any other, elimination method. And the another type where you can apply elimination method, it will be shown now. Now, let's take this example of CLAT PG 2022 paper. So here, this is a question from 2022 paper. So in this question, they are asking which of the following judgments that's given in this passage, given in these options, they relate to right to peaceful protest. Okay. So now let's see, we have four options. One is MC Mehta versus Union of India. Second is Association for Democratic Reforms versus Union of India. Third is Anuradha Basin versus Union of India. Fourth is Amit Sahini versus Commissioner of Police. Now, suppose you don't know what's the correct answer to this question. So what we can do is, first we can eliminate MC Mehta, because MC Mehta we know it usually relates to environment law, and coming no cases coming under PL related to environment law. So this is related to right to peaceful protest. So we can eliminate MC Mehta versus Union of India. Third thing, if you had followed news and everything, you would know Anuradha Basin versus Union of India is the case related to the internet blockade in Jammu and Kashmir. So that is again right to that's a freedom of access to internet, and that does not deal with peaceful protest here. Then we have two other options, that is Association for Democratic Reforms and Amit Sahini. Now the correct answer to this question is Amit Sahini versus Commissioner of Police, because this judgment relates to the protest in Shaheen Bagh actually. Now we can try to eliminate ADR because ADR is NGO, and what they usually deal with is democratic reforms like elections and matters like that, and not usually with protests. So that's how I had applied my mind when I eliminated this option, because I wasn't sure what was the correct answer. I went with such a rationale. So we can use such elimination method to arrive at correct answer, so that you don't have to leave the question, but you'll also be able to get the correct answer. So these are our exam tricks and that tips that you can apply while writing CLAT exam. Pinto, over to you.
And that's pretty much it. That is our presentation. We're also open to taking a couple of questions. And before that, we'd like to talk about what we're doing, right? So you might think this is a lot of work, because we are talking about a lot of judgments, Supreme Court judgments. You have constitution, you have criminal, and Sukanya actually dealt with all the aspects, right? So this might look like a very tedious task, and you don't even have a month to the exams. That's when our help really comes into the picture. We believe we can help you in a productive manner, because what we do here is we have different courses for you that you can choose from, where we have culled out important judgments and we are giving you the facts of the judgment in a very easy manner, so that you're able to understand, you have the issues, and then we're giving you the judgments in paragraphs, so that you will have like one particular underlined thing, and then beneath that you would have an explanation as to what the court said. Did the court rely on any other judgment, or was there a dissenting opinion? Why was there a dissent? What was the rationale? All these aspects would be covered in a very extensive manner. And we also, like I mentioned earlier, we have tables, we have Venn diagrams, we have so for example, if there is a case on promotion, so there are so many what do you say, cases that deals with promotion, right? So can there be reservation in promotion? So we have sort of summarized all those cases in one judgment itself, so that when you read that judgment, you would know, okay, these are the 6-7 cases, and this is what the court said, in which year the judgment was. So when you're studying one judgment, you're also getting a very or a fair idea of the other judgments as well, which will really help you with regard to preparing for your exams. And that's the method that we have taken, because what is the point in just giving you one judgment and the court is referring to a couple of other judgments in that judgment, and you don't know the facts, or you don't know what the court said in that judgment? So what we are trying to do is we are trying to give you a very comprehensive analysis of the judgment, so that you know that and much more. So we have two options currently. We would urge you to look into our, to look into our, what you say, our store. You can see what we are doing there, how many judgments we are giving. All of that would be available. So can you see that? Yes. So
Yeah.
basically, we're also giving out a discount coupon, a promo code that is Rapid Legal 30. You will get up to 30% on selected products. So that is exclusive for all the people who are in right now. That is up to 30% discount you will get on, if you visit our store. And I think
We
for
need to.
everybody's benefit,
Hello, sorry. Are you able to see the
yes,
slide that's
yes,
been shown? Yeah. So
yes,
there are
yes.
two discount codes that needs to be.
So we have two coupon codes. So one is Smart Revision Plan, that is Get Smart, that is our promo code. And for Rapid Revision Plan, we have Rapid Legal 30. And we would like to put out the link. So Kanya, can you please put out the link of our store in the chat box?
Yes, yes, I will do that.
Yeah, so I think that will be easier for everybody to uh, look into, and you can choose whatever option you think is fit. If you think our analysis helps you, or if you're very overwhelmed in terms of the exam, worry not, we are here to help you, and you can just visit our store, and then you will have a fair idea. And we're also open to taking questions if you have any.
Guys, if you have any question, you can write in the chat box. If you have any questions, you can write in the chat box. Otherwise, we will proceed. Okay,
I think
thank
if
you.
there are no questions, we can move forward.
Yes, ma'am.
Yeah.
So thank you, Miss Sukanya Rintu, ma'am, and Miss Sukanya S, ma'am, for such a wonderful session. Now, I would like to call Miss Sakshi Sharma for vote of thanks. Just a second, ma'am. I think our founder is not here. I will just call him.
Um, so, thank you, Sukanya and Rintu ma'am, and thank you to the team of SR CLAT Notes, firstly, for taking this wonderful session. I'm pretty sure that all the students who are here have benefited from the same. And I thank you so much to ma'ams for taking out the time, valuable time, to hold this session and to teach the students who are present here on how to crack CLAT PG, and on also the top three Supreme Court judgments and all the other judgments as well. Thank you so much, ma'ams, and it was great having you all here.
We will providing the uh, feedback form link. So kindly fill the feedback form to get the certificate. Ma'am, there is a one question. Ma'am, how can we remember all the articles under constitution law are clause and sub are as there are clause and sub clause?
So this is a very tricky question actually, because this is also a matter of memory that you need to have. So one way that you can do is, rather than studying all the articles, maybe you can only focus on the important articles and the sub clauses under that, because you can be sure that questions might come from these parts. So mainly your article 14, 19, 21, also director principle of state policy. You need to focus on these provisions especially. So just focus on these provisions. And also important subject for CLAT PG as shown in the diagram. Actually, you need to focus on constitutional law because at least 25% or 30% of the paper comes from constitutional law. And apart from that, you need to focus on criminal law, Evidence Act, and CRPC and IPC, and also that mainly on judgments, and also on contract law and some aspects of company law, and should also have a basic understanding of environment law and international law, because a passage from international law is usually seen in the CLAT exam.
There is a one another question also. The constitution is the important subject for CLAT PG.
Yes, constitution is one of the most important topics for CLAT PG, because all the NLU, right? Without constitution, we won't have an NLM course. So constitution is compulsorily there for your exam also. At least, as I mentioned earlier, you can expect 25 to 30% of the paper will be from constitutional law.
Even the judgments that, just to add on to that, even the judgments that we've discussed also, if you know look at any of the judgments, whether be it same sex legalizing same sex marriage, even Jallikattu case, or even certain aspects on center state relationships, or even the other judgments that we have referred to, almost 8 judgments were covered today. Everything has a constitutional element to it, unless of course it is an entirely different principle. Say it's directly on, say, environmental law or criminal law. Like for example, 313 is CRPC and it's criminal law. But generally all these, and that's how you understand also, right? When it's a constitutional matter, it also, the implication of the judgment also would be high, and that's how you select whether this judgment is important or not, for not only for CLAT PG but for any competitive exam of a similar pattern. So that's what even we have we have understood from analyzing the papers for the past 3-4 years. So, and that's why also it's very clearly mentioned in the site also, constitution is one of the most important areas to focus.
Thank you so much, ma'am. I think there are no questions left. Thank you so much for joining the webinar and conducting the. Thank you so much, Sukanya ma'am and Rintu ma'am. And thank you all to the participants who joined the session and learned something. And we have provided the feedback form in the chat box. Kindly fill that feedback form, and then you will get the certificate. Thank you so much, and have a good day.
Thank you.
Thank you.